3. Legal machinery for settling disagreements. Legal machinery to settle disputes is necessary, and courts have been substituted for the early methods of trial, which were very crude. In England, trials by oath, by ordeal, and by battle were expected to give redress and to establish justice. The first was not based on the oath of a witness that he had personal knowledge of certain facts, but depended on the testimony of a number of people who swore that they believed the person guilty or innocent. Trial by ordeal would seem to us an even more impossible method of determining justice. The accused was forced to take a red-hot iron in his hand, or to plunge his arm in boiling water, or to be thrown into cold water. If he was not affected by the hot iron or water or could swim in cold water, he was innocent. Otherwise, he was declared guilty. These two means of settling disagreements were used chiefly in criminal cases. Trial by battle was fought with cudgels in the presence of a judge, and if neither of the parties was overcome, continued from sunrise until night. This method of trial was practiced to some extent in England until 1819. Now disputes are settled in court by a trial before a judge or before a judge and jury. The early jury. One development of the English law which was different from other systems was the trial by jury, but the original jury was not like the jury of today. It consisted of an indefinite number of men who were chosen because they already knew something about the cause at issue, and merely reported this knowledge. It was many centuries before the jury came to be what it is today, namely, a body of 12 men who must give a unanimous verdict based upon the evidence presented to them by witnesses, who are under oath to give true testimony. The admissibility of evidence is regulated by rules, and the counsel for the respective litigants largely control the modern trial. The term court, like the word law, has more than one meaning. Blackstone defined a court as a place where justice is judicially administered, but when reference is made to the jurisdiction of the court or the decision of the court, it is clearly applicable to the judge who is acting in his official capacity, and refers to a person rather than a place. Jurisdiction. A court has either original or appellate jurisdiction, depending upon whether it has the power to hear and determine controversies in the first instance, or upon appeal to review and correct the decision of an inferior court. A court also has general or limited jurisdiction. If it has general jurisdiction, it has the power to decide all controversies, but if the jurisdiction is limited, it can decide controversies of a particular class only. Courts which have to do with the settling of estates are an example of limited jurisdiction. Sources of federal and state laws. The federal government and each of the 48 states have a complete system of courts. The written law of the federal government consists of the federal Constitution, the treaties made by its authority, and the acts of Congress. The written law of the individual state consists of the state constitution and the statutes enacted by the state legislature. Judicial power placed in the Supreme Court. The Constitution of the United States provides that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The Supreme Court has original jurisdiction in cases affecting certain representatives of the government, in cases in which a state is a party against another state. In all other cases, its jurisdiction is appellate. Its function is most important, as it carries the responsibility of finality in important and far-reaching decisions. Other federal courts. Next in order of importance is the United States Circuit Court of Appeals. The judicial districts of the United States are divided by groups of states into 9 circuits, and in each of the 9 circuits there is a court called the Circuit Court of Appeals, which hears appeals from the decision of the district courts. Each of the 9 circuits is divided into districts, and in each district there is a district court. Sometimes a state constitutes a single district, while other states contain 2 or more districts. The district courts exercise the larger part of the original jurisdiction vested in the judicial department of the federal government. There is a court of claims which was established to determine claims of individuals against the United States government. Also a court of customs appeals and a commerce court, both of which have jurisdiction over special classes of federal cases. State courts. The systems of courts in the various states differ greatly from each other but have some general features in common. In all states there is a court of final appeal, which may be the Supreme Court or the Court of Appeals. In some states there are courts of intermediate appeal as well. There are courts of general original jurisdiction, courts of inferior original jurisdiction, and courts of special probate jurisdiction. The courts of general original jurisdiction are usually called circuit courts, district courts, courts of common pleas, or superior courts, and the inferior courts, which have limited jurisdiction in civil and criminal matters, are called by a variety of names just as courts. Police courts, magistrates' courts, etc. The court of special probate jurisdiction, which usually has to do with guardianships and adoptions, as well as with estates, is ordinarily called the probate court, but in some states is called the orphans court or the surrogate court. Special courts. The two special courts which have the most to do with family relationships are the Juvenile Court and the Court of Domestic Relations. They are the most recent developments in legal procedure and show the present trend towards social legislation. Every state has developed some form of a juvenile court for children's cases. The jurisdiction includes the group of children known as neglected, dependent, and delinquent. The courts of domestic relations, or family courts, as the name indicates, have to do with the various difficulties and relationships of the family. The jurisdiction varies even in these courts, but in those having the widest scope it includes divorce, non-support, adoption, guardianship, and crimes against children. In some states it also includes the function of the juvenile court, thereby embracing in its jurisdiction every action which affects the family. Family conflicts. There is an advantage in bringing all controversies which have to do with the family into one court, with the records centered in one place. This seems a logical procedure to avoid the confusion that results in many states when divorces may come under the jurisdiction of one court. Action for non-support be brought in a different court, and guardianship or other actions affecting the child come before still another tribunal.